Bernard Waiguru Mwangi is charged with the offense of traffic narcotic drugs contrary to Section 4.2 of the Drugs and Psychotropic Substances Control Amendment Act of 2022. The particulars of the offense were that Bernard Waiguru Mwangi on 18th January 2024, at Kigumo area, at Losogwa in Nyahururu sub-county, within Laikipia County and others before court trafficked by storing drug, namely cannabis sativa, in a container serial number KKTU 7447400 22GI, maroon gray, now to wit 1,422,000 grams with a market value of 41 million in contravention of the said act. The accused person was pleaded not guilty. He was granted bond of Kenya shillings 1.5 million with the surety of similar amount. The prosecution called for evidence of 5 witnesses in support of its case. That is Chief Inspector Laban Rotich, who was not cross-examined by the accused. PW2 was PC Morris Mucheke. He was not cross-examined by the accused. PW3 was Daniel Cheriot Boit, who is a government analyst. He was not again cross-examined by the accused person. PW4, Corporal Edward Esanya, who took as the scene of crime officer. There was no cross-examination. And the 5th witness was PC Franklin Mulei, the IO, who testified and was cross-examined by the accused person. And that marked the close of the prosecution case. Accused person was placed on defense. He gave sworn evidence. He did not call for evidence of any witness. He denied committing the offenses charged with. And this defense was that he was approached by some 2 gentlemen to inform him that one Robert Mwangi was looking for a plot to buy. He said that he showed interest and agreed to sell his plot to Mwangi. That he met Robert and they went to ascertain the status of the land and at the land's office in Nyahururu. That the title deed had not been issued. That he had inherited the land from his deceased father. That he was only paid Kenya shillings 5,000. That Robert went and placed the container on his land before even buying the land and without his knowledge. That he later came to know that the container contained cannabis sativa. That closed the defense case. And the issue for determination is whether the prosecution proved the charge of trafficking cannabis sativa by the accused person. Now, it is well settled law that the burden of proof lies with the prosecution. Although the accused person gave sworn evidence in his defense, I find that the accused person's defense is based on mere denial and evasion. His evidence that he was approached to sell land to one Robert Mwangi did not controvert the prosecution's case. The accused person did not prove any documentation or call for any witness to show that he was in the process of selling land to one Robert. His testimony that was given 5,000 by Robert to enable him to follow up on the land title from the land registry was not established through his defense. On the contrary, the court observed in his proceeding that the accused person received 5,000 as storage fees for the container, knowing it to have contained cannabis. The container was concealed with corrugated iron sheets in order to hide it from the authorities and public eyes. Bearing the above in mind, I do find the prosecution proved its case beyond reasonable doubt on the charge against the accused. The evidence it presented have produced convincing and credible evidence of charge of trafficking narcotics by the accused person. The accused person is found guilty as charged, is therefore convicted under Section 215 of the Criminal Procedure Code. Right of appeal, 14 days. So I have considered the provisions of Section 4.2 of the Act, that is the Narcotic Drugs and Psychotropic Substances Control Amendment Act of 2022, which provides for a fine of Kenya shillings 50,000, not less than 50,000, or 3 times the value of the substance, whichever is greater, or to both fine and imprisonment, or to imprisonment of 50 years, or both fine and imprisonment. The crime of possession and traffic of narcotic substance has become rampant in Laikipia County and generally across the country. Many youth, especially students, have been entrapped into abuse of drug use, leading to addiction. The use of these substances has wasted many lives, especially those of youth and students. Therefore, in the circumstances, I do sentence the accused person to pay fine of Kenya shillings 50 million, or in default, 30 years imprisonment, to serve as an example, and to deter other members of public engaged in such vice. The 63 bags of cannabis sativa produced as exhibit number 12 is hereby forfeited for destruction in the presence of the DCC Nyahururu, the OCPD Nyahururu, DCI, the OCS Nyahururu, the court administrator, and the public health authorities. The corrugated iron sheets and the timber is hereby forfeited to the state. The container, serial number KKTU 744-74400, 22 GIA, produced as exhibit number 6, is hereby forfeited to Nyahururu law courts for use, since no one has claimed for its ownership. Right of appeal, 14 days.